An anti-gun judge goes after the Second Amendment in Maryland. Let's go ahead and talk about it. What's up, Wolverines? Welcome back to my channel, John Crump News, where we discuss 2A issues almost every day. My name is John Crump. I'm an investigative journalist, and I keep an eye on the gun space. I live in Virginia, very, very close to the Maryland border. Loudoun County is on the Potomac, and on the other side of the Potomac is Montgomery County. And Montgomery County has passed some of the strictest gun laws in the nation. The liberal hive mind that lives in Montgomery County does not like the Second Amendment, they do not like guns, and they especially do not like the Bruin Decision. The Bruin Decision said that you cannot deny a citizen a right to bear arms outside the home. So Maryland went from may issue to shall issue. In fact, I have a Maryland concealed carry permit. Bruin also got rid of intermediate scrutiny, which is interest balancing. It basically weighs the interest of the state versus the interest of the citizens. So that's out the window. Bruin also said that any gun law has to be consistent with the text, tradition, and history of the Second Amendment. But there is a caveat to that. And that caveat is something called sensitive areas. The Supreme Court said that certain areas could be designated sensitive, but it has to be used very sparingly. Basically, it has to be a government building or courthouse and certain types of schools. But it cannot be everywhere, and it cannot be just because that's where people gather. Montgomery County took the sensitive areas and expanded it to almost everywhere. So schools, polling places, parks, government buildings, anywhere. And not only that, but they also put a 100-yard barrier around these areas. So anything within 100 yards would become a sensitive area, which would mean almost 100% of the county is now a sensitive area and you cannot carry, even though the Supreme Court said that you could. So Maryland shall issue sued the county along with several other plaintiffs claiming that their law runs afoul of the Second Amendment. And they asked for a temporary restraining order and a preliminary injunction. In order to get a preliminary injunction, you have to show that you are likely to succeed on the merits of the case and you are suffering irreparable harm. Well, now a liberal whack job judge has ruled against Maryland shall issue. The judge ruled that the Founding Fathers could not have known the way that technology would advance in firearms, which is kind of ridiculous because if you look at the technology for other things, such as the internet and all that, the Founding Fathers had a better chance of knowing that the firearms technology of this time would advance to this level than they would know about TV, radio, or internet. So does that mean that we don't have freedom of speech because the Founding Fathers cannot have envisioned that we had that type of technology in our future? Another thing that the judge did say is an analog doesn't have to be an exact replica, but there's nothing even close to Montgomery County's laws from the founding of the Second Amendment. But the judge tries to get around this by doing what Florida did and stating that it is not the date of the ratification of the Second Amendment that is important, but the date of the ratification of the 14th Amendment. The 14th Amendment extended the rights of the people guaranteed under the Bill of Rights to the state level. And the judge stated that there was gun laws in 1868, the year that the 14th Amendment was ratified. But if you look at when that happened, that was right after the Civil War, and those laws were to prevent black people from getting firearms. Basically, they are racist laws. But all gun laws are racist, so there is that. So the judge went by the 14th Amendment. And we have seen this in Florida, and we are seeing this all over the place. In fact, Giffords, Everytown, and Brady are actually pushing the judges to use racist laws in ruling against the Second Amendment. So Maryland shall issue is going to appeal to the Fourth Circuit Court of Appeals, which I'm not exactly 100% confident in. If it was the Fifth Circuit or Sixth Circuit, I would be more confident because the Fourth Circuit Court of Appeals is very, very anti-gun. Although I don't see how they can reject Bruin like this district judge did. In the end, I think Maryland shall issue will win the case at the circuit level, but I cannot be 100% certain. There is other similar cases like the GOA case out of New York and the SAF FBC case out of New Jersey that is at the circuit level that might be decided before that. And those laws are very similar to the regulations that Montgomery County has on the books. So either way, gun control will die a slow death. Unfortunately, this is not the decision that I would have liked to see happen, but it's the decision we got, and we will continue to fight. The battle will go on. The war will go on. This is a war for our rights. We will lose some battles and win some battles, but we are winning more battles than we are losing, so that is a good thing. Gun laws are on borrowed time, and they will all get knocked down thanks to the appointment of a bunch of conservative judges to the Supreme Court. All right, guys, that's it. I will be back in Virginia tomorrow, so I'll see you from there. Stay ever vigilant, stay ever free. I have a lot of ways you can support me, whether it's my Patreon, whether it's my locals, or you can just hit that join button down below. That would really help. And of course, all the documents are down below. Like, comment, and subscribe. And with that, we are out of here for today. Hope you have a great weekend, and Wolverine's mother...